Gentlelady yields back. The gentleman from North Dakota is recognized.
So there's a carjacking outside of 7-Eleven in downtown Washington, D.C., and the cop calls the CEO of Bank of America and says, I need every person in your bank who's ever bought a gun anytime, anywhere. It's an ongoing criminal investigation. Everything Everywhere All at Once won the Oscar last year for the best movie, but it's not the standard for a Fourth Amendment warrant. And I think this is about as important of a hearing as we can have, because if they're doing it to members of Congress's staff, reporters who are engaging in all of this, imagine what's going on at another time. By the way, the Supreme Court agrees with me, and we'll get into that in a little bit. When the Bank of America provided the FBI a list of people who made financial transactions with their Bank of America card in Washington, D.C. between January 5th and January 7th, 2021. The practice of sweeping up thousands of Americans without probable cause and specify in a search for specific suspects is inconsistent with the specificity requirement of the Fourth Amendment and the entire criminal justice system. Considering how many Americans use Bank of America credit or debit cards, this list must have included thousands of people. This list almost certainly included members of Congress, their staff, who were performing constitutionally mandated functions, as well as reporters who were engaged in First Amendment protected activity. Countless of other individuals were swept into this surveillance without probable cause. The list included people who had a history of purchasing a firearm at any time, which is a constitutionally protected activity. So we likely have violations of the First, Second, and Fourth Amendment. The fact that Americans' data is handed over to the feds on a fishing expedition by the banking industry because their customers were present in a particular region or purchased a constitutionally protected item is unacceptable. And I reject any argument that this financial information is subject to third-party doctrine and therefore an exception to the Fourth Amendment. And I've been arguing this for years. The third-party exception in the modern economy threatens to make the Fourth Amendment irrelevant. The Fourth Amendment it's survived telephoto lenses, drones, listening devices, tracking devices. The Fourth Amendment has proved to be incredibly resilient. But this is the place. This is the place where Congress has to act. Because the Supreme Court seems to agree with that concern based on Carpenter v. U.S. Mr. Michel, the majority opinion in Carpenter stated that the cell site location information is, quote, detailed, encyclopedic, and effortlessly compiled. Is the financial transaction data that was released here any less detailed, encyclopedic, and effortlessly compiled in relation to a Fourth Amendment legal analysis?
I don't believe.
Can you imagine any judge in the country who would make a probable cause finding to authorize a search warrant for all of this detailed financial information on this many people with this set of facts?
No.
Mr. Tedesco?
No.
There's also similarities with this in U.S. v. Chatry. A federal court found that a geofence warrants violate the Fourth Amendment. Geofence warrants are a practice where law enforcement seeks location data on any device within a specific time and geographic region where a crime took place. The court found that it is insufficient for law enforcement to obtain the data based solely on information that a suspect possessed a cell phone while in the general area of where a crime was committed. Beyond the court's concern with probable cause, it highlighted that no judicial review whatsoever was attained and law enforcement has unchecked discretion to seize the more intrusive data. Mr. Michel, are those the same concerning factors presented with the financial data that was turned over to the federal government in this case?
Yes.
Mr. Tedesco?
Yes.
Mr. Knight?
It sounds very similar.
My colleagues across the aisle have raised many concerns about broad violations of privacy of financial or technological institutions in trafficking private user data or revealing it to government authorities. In fact, during an Energy and Commerce hearing debate on comprehensive data privacy, there were several amendments to prohibit the collection of geolocation data on facilities such as Planned Parenthood that ban the transfer of that data to law enforcement or to government authorities. And we know that the CDC was collecting data to see if people were going to church during quarantine. Church during quarantine. This conversation, how we deal with this, is the fundamental question we have to answer as we move forward. And we can talk about January 6th in the event, and we can talk about all of that, but there were thousands of innocent people that went to Bass Pro Shops in Virginia in the 2 days before and after January 6th. Doesn't matter how bad you think the event was or where it was or whatever, you cannot get a warrant on somebody for exercising their constitutional rights. And if you can't get a warrant for somebody to do it, then we have to create a situation where banks and large corporations or anybody else or third-party data brokers, by the way, are allowed to sell that information, and law enforcement is allowed to obtain it without getting a warrant. This is a fundamental question. It's a perfect place to have it in this hearing, and it is exactly what happened in this case. And with that, I yield back.
Gentleman yields back. The gentleman from New York is recognized.
Thank you, Mr. Chairman.